accept our invitation and to deliberate on this topic, which is day in and day out being confronted by our members in the day-to-day practice. He is master on the subject. He has contributed to the ICI publication also. I welcome all the past presidents, the seniors, the participants, and the office bearers. With this, a few announcements that tomorrow we are having one cricket match on President 11 versus Secretary 11. The final players will be finalized from that match, but we have one fellowship match also where non-expert on the cricket can also have the benefit of fellowship. So those who are interested can register and take part of it. On January 1st week, from 6th to 10th, we are having an RRC program also. And with this, I welcome you all and request Karan to take the proceedings further.
Thank you, Riken Bhai, and good morning and welcome everyone. So, in Professional Development Committee, we believe that all CAs should specialize in at least some area of practice, and we believe that it would pay off later on, going forward. And we have been trying to conduct lectures on such different areas of practice which, any of us chartered accountants can focus on. So in last few years, we have had a series on mergers and acquisitions, restructuring in companies, MSME subsidies, startups, opportunities in gift cities, opportunities in Dubai. Apart from that, we have had lectures on wealth management, futures and options. So these are all areas which we believe that us chartered accountants can play a major role, and we should focus on. And such one area is also succession planning. Generally, all our clients have succession issues or succession questions in mind, and they ask us also time to time. And this is something that few of us can focus, and there are a lot of different part of this subject that we would like to understand from Mr. Anup Shah today, who is a authority in this subject. So he is a fellow chartered accountant, and he has also completed his PhD in commerce from Mumbai University. He is also a law graduate, and he has done his business consultancy studies from Jamnalal Bajaj Institute of Management Studies. So he is a senior partner of Mr. Praveen P. Shah and Company, and he has over 25 years of areas in international estate planning, business restructuring, capital market regulations, foreign investments, international taxation, etc. He has contributed articles and papers to several publications, including the CA Institute Journal. And he has delivered talks and seminars and workshops across India. He is also board member of number of companies that are here. So we would now like to invite Mr. Shah, take the stage. Yeah, and before that, I would request Ashwin Desai to come and hand over a memento to Anup Shah. Yeah.
Good morning, friends, and thank you for inviting me to speak today. In fact, Karan has been trying to coordinate something, but somehow or the other, it's been very difficult. But since I was here in Ahmedabad to give a lecture yesterday at the FEMA RRC of the chamber, it dovetailed beautifully and could make it here with all of you. So, as he mentioned, succession planning is something which there is a lot of professional opportunity to work in. And plus, this is a topic where everybody is personally also interested. And that's why amongst all the professional topics, this is something which is closest to my heart. I mean, I really enjoy working on a succession planning assignment or speaking on a succession planning topic, as opposed to, say, if I would be speaking on FEMA or restructuring or something of that sort, which is only professional. This is something which deals with interpersonal relationships. It deals with the human psychology. It deals with the human nature. Plus, it deals with law. It deals with ancient Hindu law. It deals with how we've been fighting across generations. I mean, ever since if you look at Mahabharata times or if you look at Ramayana times, it's all a matter of succession planning. Everything in India has originated because of succession issues. And today also, if you were to go down the corporate path, you'll see various companies fighting. So nothing has changed in so many years in India. Nothing has changed internationally. Everything, and you'd see in companies like Louis Vuitton or in Gucci or in Lacoste, it's all succession issues. So I believe a succession issue could make or mar the company's future. You could have a beautiful company which is running well and the promoters start fighting and everything, all hell breaks loose. And most of the times the problems arise because people don't plan. Planning, if you don't plan, you are planning to fail. So failing to plan is planning to fail. And I think nothing exemplifies this statement more than in the case of succession planning. And that's where the family patriarch or the matriarch, if that's a lady who's running the show, has to take the lead and has to do it at an early stage. You can't keep pushing it that I'll do it someday. It's not urgent, it's important, but it's not urgent. No, it is urgent. You need to do it yesterday. Only then will you get the time to put things in place. It's not just that you make a will and end of the matter, or you set up a trust and it's the end of the matter. You need to take various steps after that to ensure that the succession planning which you've done falls in proper place and then goes through the entire regime. Therefore, my topic, life is uncertain, so plan today. What is the scope of estate planning? I mean, this is a topic on which I can speak for not hours, days. It's so close to my heart that I can just go on talking. And I go on writing. If you look at my articles in BCA journal, most of them deal with succession planning. But if I were to look at it in a broader nutshell, it's on death, you have two main forms, nomination, which is more basic, and a will. HUF, most of the Hindu families in India have an HUF. Now, what are the issues in relation to an HUF? Gifts and release deeds, family trusts, that's a more sophisticated form of planning, and family settlement. When there's a dispute and there is no other resolution mechanism, a family settlement is the best way to resolve issues. What are the assets to be considered? So, home, office, land, tenanted premises. In a city like Mumbai, not so much in Ahmedabad, but in a city like Mumbai, where tenancies are very valuable, tenanted premises become very valuable. Bank and fixed deposits, securities, insurance, mutual fund, digital assets. They also become important in today's domain. Crypto, if you have bank lockers, online passwords, arts and paintings, foreign assets. In the era of LRS, where people are buying foreign shares, foreign property, foreign assets, how do you plan for those? And your other jewelry, gold, and precious metals. So first, let's look at what happens if there is no estate plan, which is most common in India. Most people would defer this, push it under the carpet, I'll do it tomorrow. So what happens if a person passes away without any form of estate planning? Now, when a person dies, you could divide it into two parts, what we call in law as testamentary succession or intestate succession. What do these terms mean? Testamentary means he made a will which was valid and then died. That's called testamentary. Intestate, he either did not make a will or he made a will which was not valid. Now, if a person dies without making a will, then the succession law applies. And in India, currently we don't have a uniform civil code. So therefore, the law which is applicable is based on the religion which the deceased was professing at the time of his demise. So Muslims would be governed by Sharia law. Hindus, Jains, Buddhists and Sikhs would be governed by the Hindu Succession Act of 1956. Anybody other than a Hindu or a Muslim, that's a Christian, a Parsi, an Anglo-Indian, would be governed by the Indian Succession Act of 1925. So these are the three different types of laws which will apply based on a person's religion. Now there is a fourth law which applies in the state of Goa. In Goa, irrespective of your religion, you are governed by the Portuguese Civil Code. Goa was a Portuguese territory till very long, even after independence, and hence they have continued with the Portuguese Civil Code. If you recall, in the Income Tax Act, we have a section 5A, where we used to learn in our CA days, comunidad beno doas, that is Portuguese couple, married couple, file a joint return. You don't have a concept of a joint return in India. Goan couples are the only ones who do that because they are governed by Portuguese Civil Code, which is like a uniform civil code. Now Uttarakhand has a UCC, Goa already had a PCC, and going forth, India may have a uniform civil code. Then all these different laws will cease to apply, and they'll all be governed by one law. Now, if a person has made a valid will, which is known as testamentary succession, then how the will should be made? Now, for anybody other than a Muslim, the law which lays down how a will should be made is the Indian Succession Act of 1925. So the Indian Succession Act has two roles to play. Part 1 deals with intestate succession for Christians, Parsis, Jews, etc. Part 2 lays down how a will should be made for Hindus, Jains, Sikhs, Buddhists, Christians, all of them. Muslims again are governed by the Sharia law, and Sharia law is different for Shia Muslims and Sunni Muslims. So again, it is an interpretation of Quran and the various prophecies which have been laid down, where the interpretation matters, and that is how Shia and Sunni Muslim Sharia law differs. There's a concept of death and domicile for a person who is non-resident in India. This is very interesting. So if you have a foreigner who has assets in India, then which law applies? So if he has movable property in India, then it is the law which is applicable of his residence. So if a Frenchman dies leaving shares in India, the law of France will apply to him. But if he has immovable property in India, then the Indian Succession Act applies to that. So if the Englishman has a property in Ahmedabad, then the Indian Succession Act would apply. So law depends upon his domicile. Where is his domicile at the time of his demise? Based on that, the law will apply in India. This is only for non-residents. For residents, it's always clear that it's the Indian laws which apply. Now let's look at the Hindu Succession Act, which applies, as we saw, to non-testamentary succession for Hindus, Jains, Sikhs and Parsis and Buddhists. It does not apply to Muslim, Christian, Parsis, Jews. So all these four communities are clubbed together for Hindu Succession Act 1956. It overrides all customs and traditions. So anything which has been earlier laid down, so Hindu law, as you some seniors may recall, was enacted informally by Manusmriti. So we had Manusmriti, the father of Hindu law, who laid down what is the Hindu scriptures. Then you had the Vedas, you had the Puranas, and you had all of them. Hindu law has now been codified post-independence for four parts: Hindu Marriage Act, Hindu Adoption Act, Hindu Minority Act, and Hindu Succession Act. Everything else is yet governed by customs and tradition. But when it comes to succession, Hindu law overrides the customs and traditions. It applies when a Hindu dies without making a valid will. Then the property is fixed by law. You cannot then decide that I didn't want my property to go like this, I wanted it to go like this. No. Then law takes over and the family of the deceased has no role to play. They have to take it as it comes. Now here it divides into Hindu male and Hindu female. So when a Hindu male dies without making a valid will, there is a left to right succession pattern as laid down here. First, everything goes to his class 1 legal heirs. Then it goes to his class 2 legal heirs if there are no class 1. If there are no class 2, it goes to agnates. And if there are no agnates, it goes to cognates. What are class 1 legal heirs? Son, daughter, mother, widow. These four are class 1. Father is not, mother is. Daughter-in-law of a predeceased son, all of them are, or widowed daughter-in-law as we will call them, or children of a predeceased son or daughter. They are class 1 legal heirs. If there are no class 1 legal heirs, then it goes to class 2. First it will go to father. If there is no father, it goes to brothers and sisters equal, siblings. If there are no siblings, it goes to grandparents from the father's side. If there are no grandparents from the father's side, it goes to grandparents from the mother's side. If there are no grandparents from the mother's side, it goes to the father's brothers and sisters. If there are no fathers, brothers and sisters, it goes to mothers, brothers and sisters. Assuming there is no class 1, it goes to agnates. Assuming no agnate, it goes to cognate. What is the difference between an agnate and a cognate? Anybody related wholly through males is an agnate. Anybody related not wholly through male is a cognate. So my father's brother's daughter, that is my cousin sister, she would be my agnate because the commonality between us is males, my father and her father. But my mother's brother's son, my cousin brother, will be my cognate because the commonality between us is not wholly males, it is my mom and his father. So then he is my cognate. So first precedence is agnate, second precedence is cognate. India is always a male dominated society, therefore this is the pattern which we follow. I am surprised that after so many years of independence also we have not been able to change our male dominated society, but this is the reality which we live in. So looking at an example, a person died, a Hindu male, leaving behind his mother, father, wife, son, daughter-in-law, daughter, son-in-law. How does the succession pattern apply? Mother, class 1. Father, not covered. Wife, class 1. Son, class 1. Daughter-in-law, she will not get because her husband is alive. Daughter, class 1. Son-in-law, thankfully will never be class 1. So, 4 class 1 heirs, 25% each. Each of them would get an equal share in the deceased estate. In the second case, he leaves behind 2 brothers, 3 sisters and his mother's parents. All of them are class 2 legal heirs, but in the order of hierarchy, siblings come first. So 2 brothers and 3 sisters, they will get a 1/5 share. Nothing will go to mother's parents. Female intestate, totally different way of looking at things. Now here, what it says that the property which a Hindu female has is her absolute property, and she is free to do whatever she wants with her. Section 14(1) of the Hindu Succession Act. And how can she earn this property? By inheritance, partition from an HUF, in lieu of maintenance from her father-in-law or husband, by gift, by own skill, that is by working as salary or by business or by buying something. She can deal with it as she likes in any manner she likes. However, there is an exception to this clause. It says that if you received any property as a Hindu female with a limited right of interest, then you cannot deal with it as you please, because then it has to go as per the limited interest you received it. So this applies when a property is received by gift, will or any other instrument providing a restrictive right of enjoyment. And there's a very famous case of Sadhu Singh where a husband bequeathed a bungalow to his wife and said, under my will, you will have the right to residence in this bungalow for your lifetime. However, after that, it goes absolutely to my 2 nephews. The wife got it under the will, but she said, I don't want to give it to my husband's nephews after me. I want to gift the property in my lifetime to the Gurudwara to make a Gurudwara here. So on one hand, wife who had a limited right wanted to gift it to the Gurudwara. Other hand, the nephew said, look here, we've got it under my uncle's will, but till you are alive, you can stay in it, but you cannot gift it away. The matter went to Supreme Court, and Supreme Court said, no, as per section 14(2), you do not have an absolute right. You got it as a limited right. You cannot convert that into an absolute right. So it has to go to your nephews and you cannot gift it away to the Gurudwara. This decision was rendered by a 2-member judge. Last month, the Supreme Court said there is a lot of controversy on this. So now it has been referred to a 3-member bench, this issue, that if I have a limited right, can I make it into an absolute right and deal with my property as I want for a Hindu female? So it'd be interesting to see how the Supreme Court looks at this issue. Now, what is the succession pattern when it comes to a Hindu female dying without a valid will? No concept of class 1, class 2, agnate, cognate. All that was for a male. Here, first the son, daughter and husband, they get an equal share. So as many number of sons, daughters and husband, they will all get an equal share. If nobody is there, then it goes to the legal heirs of the husband. So you assume that the husband has died intestate and who would be his legal heirs, and then they would get it. If there are no legal heirs of the husband, then they will go to the parents of the lady. parents of the lady not being there, they will go to the heirs of the father, as if the father died intestate. Legal heirs of the father not being there, they will go to the legal heirs of the mother, as if the mother died intestate. Again, the order of succession is from left to right. If you remember, when Mrs. Jayalalitha, the Chief Minister of Tamil Nadu, passed away, there was this dispute between her nephew and her niece. Nephew was an heir of the father and niece was an heir of the mother. So the Madras High Court had to determine who has precedence, and the Madras High Court ruled in favor of the nephew because he was a legal heir of the father, and they said he has precedence under the Hindu Succession Act over the legal heir of the mother. There is again an exception under section 15 of the Hindu Succession Act. The Hindu Succession Act is full of exceptions. It's like a murder mystery. Every page there is a twist. And our lawmakers were real visionaries. So, if she's inherited a property from her parents, and she dies without any children, then it goes back to the legal heirs of the father. It does not go to her husband. So, if there is a lady, she got a property from her father, and she did not leave a son or daughter, then it will, after her, not go to her husband even if he is alive. It will go back to the legal heirs of the father. The idea being that if she got something from her parents, it should go back to her parents. Similarly, if she got something by way of inheritance from her father-in-law or her husband, and she dies without leaving any children, then it goes back to the legal heirs of the husband and not to the other legal heirs. So this is only if there are no children. If she had any children, then the regular succession pattern will follow. A Hindu female dies intestate, leaving behind husband, 2 sons and parents. 1/3 share, husband and 2 sons will get, parents get nothing. Hindu female inherits a house from her father. She dies intestate without leaving a child, leaving behind her husband, father's brothers and father's sister and husband's sister. Now, here the exception will apply. Father's brother and father's sister will get it, not the husband. One interesting question, what if in case of a male or a female, there are no legal heirs, no one. We looked at 5 scenarios and there is nobody, a very unfortunate soul. There is no family member or they are not traceable. In that case, who gets it? So always remember, if you don't have a relative, government is there for you. And government will come and happily take over your property and bless you and bless the soul. So it's called the law of escheat. The name says it all. And they need to make a petition in court, and then they will be able to take over the property of the deceased, and the property vests in the government. Is stepson a legal heir? Now, this was something which Rikin Bhai was asking me in the car. That what happens under the income tax law. So section 2 of, I think section 2 subsection 15 of the Income Tax Act defines the term child, and it says child includes a stepchild. So in income tax law, stepchild is also treated as a child. But under succession law, a stepson or a stepdaughter is not a legal heir. So, and there are these various Bombay High Court, Delhi High Court decisions which have said Hindu Succession Act is different from Income Tax Act. Maybe in income tax your child is includes a stepchild, but for Hindu law, stepson or stepdaughter is not a legal heir. He or she cannot succeed to the property of the stepfather or stepmother. That is the law. Legal heirs enumerated under the Act do not cover a stepson from wife's previous marriage, and stepson cannot succeed as legal heir to the estate of a male. There must be a direct relationship. It must be natural born. What about illegitimate child? Now in the eras of live-ins, what happens if a child is born outside of a marriage? Now, here the Hindu Marriage Act comes to the rescue. It says even though the marriage may be illegitimate, a child born is not illegitimate. If a child is born out of a wedlock relationship, and if the marriage would have otherwise been valid, then the child cannot suffer merely because the parents are not married, and it bestows on him the legitimacy which a legitimate child would get. Therefore, even living relationship children are considered legitimate. We have the Supreme Court's decision in SP Balasubramaniam. And children of intestate Hindu born out of void marriages are entitled to a share in their parents' assets. So again, Supreme Court coming to the rescue of illegitimate children. So very clear bias against stepchildren, but illegitimate children, they are entitled to succeed. Sometimes, people ask me what is the logic, and I always have one line: law and logic never go hand in hand. So please do not ask why. I just interpret it. I don't make the law. Hindu Marriage Act confers no right in the property of persons other than parents of illegitimate children. So this is a recent Supreme Court decision. It said, okay, as an illegitimate child, he can succeed to his parents' assets, but he cannot claim assets in the uncle or aunt's estate. That much we are not giving you the purview. So a lot of this is judge-made law, and it's not there in the statute, but this has all been judicial reach. One controversy which got decided last year: can they claim a share in the father's HUF if they are an illegitimate child? Now, here the Supreme Court said, and it came out with a very via media, that they can claim a share in the father's HUF, but they cannot become a co-partner, they cannot become a KARTA. So it was a very unique mid-of-the-path decision that you get a share, but you are neither co-partner nor KARTA, because they said if we make you one, you will disturb others in the HUF. So we are giving you an benefit, but we can't give you a right. So it's a middle-of-the-path approach taken, and Supreme Court decision is law of the land, so we have to follow it. Now, if a person dies intestate, then his legal heirs need, in some cases or in most cases, need to apply for a letters of administration from a court. What is a letter of administration? It is a seal of the court that now everything is final. You are the legal heir and you are entitled to succeed to the property. You can get the 712 extract change, you can get the property card change in your favor. Sometimes you can even apply for a succession certificate. What is the difference between a succession certificate and a letter of administration? Succession certificate is only for movable assets like shares, securities or bank deposits, whereas letter of administration will be required if you have immovable property also. In some cases, you also have a third category known as the legal heir certificate. Legal heir certificate doesn't entitle you for any succession. It only certifies that such and such person is the legal heir of the deceased under the Hindu Succession Act, and this is his name and this is his address. That's it. So in the hierarchy, highest would be letter of administration, then would be succession certificate, and then would be a legal heir certificate. HUF, most of us being chartered accountants are familiar with it. What is an HUF? How does it work? But the succession issues are very unique. A son is not a must for an HUF. That's a myth which has been propounded that you need a son to have an HUF, and the Indian Banking Association should be thanked for creating this controversy, because they are the ones who always insisted how can you have an HUF without having a male child. They also have contributed to the myth of where is the deed of HUF. Now, I don't know under which law, and this is coming from their legal department, so I don't know which law school their lawyers went to. When they ask that where is the deed of an HUF, you don't have a deed. HUF is not created by contract or by statute, it is created by relationship. It is created when a person gets married and has a child. So that is when an HUF comes into existence. At max, you could show the birth certificate of the child, but beyond that, there's nothing more you can do. Now, on 9th September 2005, there was a watershed amendment to the Hindu Succession Act, which has created more controversy and added more fuel than what it should have held. So in this case, the pill was worse than the ill because of the way that the law was drafted. What it said, on and from 9th September 2005, a daughter of a co-partner is one who has a share in the HUF and has a right to demand partition. So a daughter of a co-partner by birth becomes a co-partner in her own right as a son in the father's HUF, and has the same rights and liabilities in the father's HUF property equal to the son. So what it is trying to say, that in the father's HUF, sons and daughters have equal rights and liabilities. Both are at par, and this amendment was only for the father's HUF, not for father's personal property. Personal property goes as per the class 1, class 2 agnate cognate waterfall mechanism which we saw in the beginning. But this was only qua the father's HUF. Sons and daughters have an equal right. What it did not specify is how, when, what is the date of effect, what is all. So all this led to a lot of controversy. Does it apply to daughters born after 9 September 2005? Does it apply to daughters married after 9 September 2005? Does it apply to all daughters whether married or unmarried but living on this date? Does it apply to have a retrospective effect, that is from 1956 when the Hindu Succession Act came into force? Does it apply to prior to the Hindu Succession Act coming into force? What happens if the daughter is not alive on 9 September? What happens if the father is not alive on 9 September? All these questions were left unanswered. It will be roughly 20 years, and next year will be the 20th anniversary. And there were lots of decisions which gave contrary views. Finally, Prakash versus Fulbanti and Dannamma versus Amar, two Supreme Court decisions came out with a unique proposition that it says daughter of a co-parcellor. So both daughter and father should be alive on 9 September 2005. Only then she is entitled to succeed to the father's HUF. If father has died, daughter is alive, she will not get a share. So that was the law prevalent which people started following. In 2020, a 3-judge decision in Vinita Sharma versus Rakesh Sharma overturned all decisions under the sun and came out with their own interpretation. It says daughters have an equal right as that of sons in the father's HUF. There is no law which requires the daughter's father to be alive on 9 September 2005. Daughter of a living co-parcellor is not the word. It says daughter of a father. So father may have died, even then daughter will have a right. Only thing required is daughter must be alive and HUF must exist as of 9 September 2005. Then she will have a right in her father's HUF equal to that of a son. Her rights are by her birth and not by her father's state of being alive or dead. If she died before this date, can her children become co-parcellors? There the Supreme Court said no, because it is her position to be seen. Exception to the rule was if the HUF was partitioned before this date, then she will not get any share. But Supreme Court added a caveat to prevent brothers from showing fictitious partitions. The partition should have been registered. Only then we will recognize it that the sister does not have a share. Now, again, some more unanswered questions. What happens to the daughter's children? If there is a son, he has a share in his father's HUF and his children automatically get a share in their grandfather's HUF. Would the daughter's children also automatically get a share in their maternal grandfather's HUF? I believe the answer is yes. Because if I have an equal right between a sister and a brother, then the sister's children also should be eligible to claim a right in their grandfather's HUF. Son's wife is treated as a member, daughter-in-law. Would son-in-law be treated as a member? This is a very difficult conversation which nobody wants to have. So, if you place it on par, logic demands that yes, he too would become a member in the father-in-law's HUF. Because if daughter-in-law is, then why daughter's husband is not? And this is something on which I've done a lot of research, but I've not got any answer. No court case, fortunately, has yet looked at this issue.
And what about daughter's children? Because then it becomes a never-ending story.
It will. That is how HUF is. HUF is a ambulatory, never-ending story. They will get a right. They will get a right. Can a daughter be a karta now, or rather, can she be karti? Now, the Supreme Court in St. Govindram Sugar Mill said that to become a karta, you have to be a co-parcellor. So how can a daughter be a co-parcellor? Because she is never. How can a daughter be a karta? Because she is never a co-parcellor. This was prior to 9 September 2005. Now that daughter is a co-parcellor, she can become a karta. The only requirement would be who is elder, brother or sister. It is the eldest child who becomes karta. So here in Sujata Sharma versus Manu Gupta, Delhi High Court had a case where there were 7 siblings and the lady was the eldest. So the Delhi High Court said the lady will become karta. If she does not want to and she relinquishes her right, it's a different story. But otherwise, even if she is married, even if she has left the father's house years ago, she now has a right to come and stake claim that I am the karta because I am the eldest co-parcellor. So please vacate and give it back to me. Can wife now be karta in husband's HUF? Look at the myopic vision of our legislation. They only amended it for daughter's rights. They did not amend it for wife's rights. Wife can only be a member in husband's HUF. She cannot be a co-partner in her husband's HUF. What logic does that have? And she will never be karta in her husband's HUF because she is not a co-partner. She will only be a member who is below a co-partner. So you may have left your father's house years ago, you will be co-partner and you will be karta. You live with your husband, you will not be karta, you will not be co-partner. What if there is a family of three, father, mother and son? Son is minor, father dies, mother is not a co-partner. Who will be karta of this HUF? Here Supreme Court again comes up with a via media. Mother will be guardian manager. Till son grows up, she can take care. Because there is no one, okay, fine, then we will give you that guardianship. Once son grows up, he becomes karta. So this is Shreya Vidyarthi's decision. So, these are, I believe it's time for a complete overhaul of the Hindu Succession Act, and we need to look at things in a more holistic perspective. And there's so many decisions. It's very easy to frame a law. Maybe they're waiting for the Uniform Civil Code where HUF as a class only will be abolished. That was the Law Commission's recommendation a couple of years ago, that HUFs have outlived their utility. Other than few tax planning issues here and there, they create more problems than they create solutions. So get rid of HUF as a class altogether, then you won't have all these problems. And I do believe the answer is correct that HUFs have outlived, but then they would need to provide a clear-cut transition and provide for stamp duty exemptions, provide for tax exemptions for people to wind up and make it a simpler structure, because HUFs are creating a lot of hurdles and a lot of litigation in courts are stemming from HUFs, especially in the northern India, in places like Punjab and Rajasthan. A lot of disputes go to court, and even in the south, in Tamil Nadu, a lot of disputes go to court because of HUFs. HUF partition, joint family, separating, everybody gets a separate share, everybody gets an asset, that is known as an HUF partition. Hindu law recognizes total and partial partition. So, total partition is entire HUF comes to an end, whereas partial could be qua an asset. You may only partition this laptop out and the rest of the HUF continues. Or it could be partial qua member. Only 2 members out of 12 may go out, the rest can continue. Income tax does not recognize partial partition, but that does not mean partial partition is not valid. HUF Hindu law yet recognizes, and it is a valid concept. Only thing will be that in income tax, the HUF will be taxed on the income arising from partial partition, but Hindu law has no problems with a partial partition. How do you go ahead for manner of partition? It could be oral, followed by a memorandum of understanding, by filing an arbitration award and arbitration suit and getting an award, by a deed of partition, which is the most common, or by going to court and getting a decree for partitioning the HUF. Who can demand a partition? Any co-partner can demand a partition. Can a wife demand partition in her husband's HUF? No. Because wife is not a co-partner, she is always a member. Can a daughter claim partition of her father's HUF? Yes. After 9th September, she has become a co-partner, so she has the same right, and she can do so irrespective of whether she is married or not. Marriage has nothing to do with that. Ancestral property, property received from 3 generations above of male lineage, father, grandfather, great-grandfather. All of this property would be ancestral. Ancestral property, there is a huge controversy going on whether it can be alienated, whether it cannot be, and every few months we have Supreme Court decisions for and against. Correct view is ancestral property can be alienated. Section 8 of the Hindu Succession Act has modified old customs and traditions. Property devolving on a person becomes his self-occupied property, and he can deal with it any way which he wants. So the Delhi High Court has very succinctly put it that after the Hindu Succession Act coming into force, for persons inheriting property from his paternal ancestors, property is not ancestral in his hands and he can deal with it in any manner which he wants. Yet, every few months we have a new Supreme Court decision and the circus continues. So this is again something which needs to be clearly laid down about the law of succession for ancestral property. Now, when there is a demise of a co-partner, there is a notional partition of an HUF, not an actual, notional. The share of the person who has passed away will be worked out just prior to his demise, and his share and everybody else's share will be fixed upon. So, if there are 10 co-partners just before his death, then notional share of each will be 1/10. Now, this 1/10 share can either be willed away or it passes by intestate succession to his class 1, class 2 agnate cognate. That is how the Hindu Succession Act has now been amended. Earlier, what used to happen is if 1/10 goes away, the remaining shares would get enlarged. But now he can either will away his 1/10 to his wife, he can make his son from 1/10 plus 1/10 and make him 2/10, and or it will go as per his Hindu Succession Act, intestate succession. So that deals with the notional partition of a co-partner demise in an HUF.
There's a probability that there's 10% of the share would change in future. Then
So HUF is an ambulatory thing. Your share increases by deaths in the family and it reduces by births in the family. So that's the law of how HUF is. It's fluctuating. It's never ending, fluctuating till a time comes when nobody has children going forward. If the progeny comes to an end, then HUF goes.
In this case,
We'll deal with it at the end.
Afterwards.
Yeah,
At
the end.
So
Yeah.
we can take the questions at the end of the lecture.
Now, most common questions which people have, I have 2 children who will inherit everything after me. Everything is held jointly with them. Why make a will? Why do planning? That's the common question which I am asked. Always remember, joint owners are only stopgap owners. Legally, they may be joint owners. Beneficially, property passes as per the will, or if there is no will, as per the succession law. Now look at it that there is a lot of flats, lot of properties. If there is no will, all the class 1 shares, class 1 heirs would end up owning shares equally in all the assets. So you have one flat which is jointly held with one son, and you have one flat which is jointly held with another daughter. Both the son and daughter will have a share in each other's flat after the father passes away. Now, when they want to separate, they have to consider tax, they have to consider stamp duty, and if they cannot, they have to consider lawyers' fees, because now they will be litigating. So, if you don't lay down a clear succession pattern and keep it joint, the legal joint ownership has no sanctity. It is only till a person dies for the society to deal with a phase. After that, it will go as per the Hindu law. So, you must plan. Otherwise, you leave behind a legacy of dispute. Now, what are your planning options? Looking at it from a pyramidal structure, at the bottom is basic planning like joint holding and nomination, which is very common and which everybody should do. More sophisticated would be wills, whereas in the lifetime, what you can do are trusts, which are the most sophisticated form of planning. Joint holder and nomination, this is a concept which is relevant for flats, bank accounts, fixed deposits, Demat, shares, mutual fund, etc. Joint holder can be either or survivor, that is he can transact along with the first owner, or former or survivor, that is he can transact only after the first holder dies. In either case, the joint holder becomes the legal owner on the death of the first holder. However, and this is very important to bear in mind, joint holder does not become the beneficial owner after a person passes away. Ownership continues to remain with the beneficiaries under the will or the legal heirs under the act in case of intestate succession. Coupled with that, you have nomination. Nomination, most of us are familiar with. What is nomination? Nominee is entitled to receive assets on the death of a person. It's a stopgap arrangement when a person dies. It's a phase for the society to deal with. So you are plugging the vacuum. Law does not like vacuum. After a person dies, who do I deal with? So they say, okay, fine, this is the nominee, please treat him as the legal owner. However, again, nominee is only a legal owner, a stopgap. Beneficial ownership as per the will, if no will, as per intestate succession. Always will or intestate succession prevails over nomination, never the converse. And we have umpteen decisions of the Supreme Court in case of bank fixed deposits, insurance policies, NSC certificates, PPFs, that it is will prevailing over nomination, not vice versa. About 10 years ago, we had this Supreme Court decision in Indrani Wahi versus Registrar of Cooperative Society. This dealt with in a flat in a cooperative society what prevails. Now, this decision was very clear and very unambiguous. However, a very great university known as the University of WhatsApp has totally screwed up this decision, and now every managing committee has a different interpretation of it. It's very clear. What it says, when there is a nomination, now I'll give you a background to appreciate the facts better. A father was living along with his wife, a husband and wife, and their married son and their family. He, for some reason, made a nomination in favor of his married daughter, and the father passed away. The society, the lady went to the society and said, look here, my father has made this nomination, I am the nominee, please transfer the flat in my favor. The mother and brother objected that we were taking care of the father, how can he make a nomination in her favor? Nomination is invalid. Managing committee sided with the wife and the son and said, yes, we will not transfer. She went to the Registrar of Cooperative Societies, they sided with the wife. She went to the High Court. High Court sided with the wife and son. Ultimately, she went to the Supreme Court. The Supreme Court said, who are you to decide whether nomination should have been made in favor of the daughter or son? Is the nomination form correctly filled? Yes. Has he correctly identified a nominee? Yes. As managing committee, your responsibility stops. Please do not get involved into succession disputes. Immediately transfer it in her favor. Whether it should go to the wife, whether it should go as per the will, whether it should go class 1, class 3, that is for a court to decide. You guys cannot have any locus standi. So, what is the bottom line? In a flat in a cooperative society, managing committee has to only check if the nomination form has been properly filled and transfer the flat in favor of the nominee after the person dies. Ultimate flat will go as per the will or as per the Hindu law, whichever applies. So that is what the Supreme Court said, not whatever you may be reading on your chats. Another controversy in case of shares in a company and Demat shares. Here, the law in the Companies Act and the Depositories Act is very badly drafted. It says nomination vests the shares in a person, overriding any other will or any other law. So here now the view taken is that nomination overrides the will, because in case of shares and in Demat shares, nominee is supreme. Now that is what even Bombay High Court single judge took a view. Then another decision of the Bombay High Court single judge said no, the earlier one is wrong. It has ignored all the Supreme Court decisions on the point. Nomination cannot override will. Will has to override nomination. Then a division bench of the Bombay High Court said yes, the second view is correct. Will override nomination. Companies Act is only badly drafted. It is not changing the law. Ultimately, the matter went to Supreme Court, and Supreme Court has now upheld will prevails over nomination even in case of Demat shares. So whatever be your nomination, it will be the will which will prevail, not the nomination. What prevails, joint holder or nomination? If you have both, what happens? Hierarchy is joint holder first, nomination next. So how do you make it? Husband, wife make each other joint holder in their accounts. After them, they make their children nominees. So when both are not alive, nominees will get into picture. One of them is not alive, the joint holder will come into the picture. So that's the hierarchy when it comes to joint holder and nomination. Coming to wills, what is a will? Will is very common. It's the last wish of a person and which prevails at the time of his demise. It is a legal declaration of a testator's intent. Testator is the person making the will, and it manifests only after the testator's demise. Will is something which you will keep changing every minute till you are alive. So there is no limit on the number of revisions which you can make, no limit on the number of revocations which you can do. Ultimately, the last will prevailing at the time of demise will be the one which will be treated as final. Who can make a will? Any person who is 18 years or above, who has any sort of property. You must have property to make a will. If you don't have any property, then what are you going to will a will? Male or female, it does not matter. An intoxicated person, a person who does not understand what he's doing, cannot make a will because you need to be of sound mind. a person who is visually impaired or who is hearingly impaired, can they make a will? Of course, but they should know what they are signing or putting their thumb impression on. Person who is ordinarily insane can during intervals of sanity, but it would be very difficult to prove that when he made a will, it was an interval of sanity. So they would need probably a neurophysician or a psychiatrist certifying that right now he is sane and he understands what he is doing. Illiterates can make a will, they can put a thumb impression. Lunatics cannot make a will because there is no mental capacity. Persons with Alzheimer's disease, can they make wills? Answer is yes, but they would need very, very clear certification from a neurophysician certifying that when he made the will, he was sane and he understood what he's doing. It was not a case of him being under the purview of a mental problem where he does not understand what he's doing. Otherwise, the will be challenged. Person with Parkinson's disease definitely can make a will. It's only a motor disease. It does not impact the brain's functioning. So if he's unable to sign, he can put his thumb impression. How to make a will? Stamp papers. Is it a must? Yes. If you watch a lot of Hindi movies, it is a must. But otherwise, you can do it on the back of a tissue paper also. So you don't need to have any sort of formal writing. Ledger papers are not required. Typewritten wills are not required. But if it's handwritten, it should be legible. So that's very important. Like if a doctor is making a will, then you should be very careful. That otherwise, it will only the chemist will be able to decipher. You need the signature or thumb impression of the testator because that is very important. I would suggest that it should be signed or initialed on every page, so that you don't have problems going forward. 2 witnesses, we'll come to that. Appoint executors. You must have executors who put the will into motion. Date the will, most important. If there is no date, how do you know it is the last will? Most problems arise because there are multiple wills floating around after a person dies, and then you don't know which is the last one. Designate legatees and beneficiary who gets what. If you don't write who gets what will happen in the will? So you may even have a universal legatee that all my property goes to my wife. End of matter. That's fine. But you must write something. Only assets owned beneficially, not where you are a joint holder. So if you are a joint holder or a nominee in somebody else's asset, you cannot put that in your will because you don't have any right there. Who can be a beneficiary? Relative, friend, employee, house help, chartered accountant, lawyers. We know of the famous case where chartered accountants got a lot of estate. Supreme Court has upheld that. Stranger to the will, that could be also anybody. You could say any person on the road is my beneficiary under the will. You can even make pets legatees under the will. But the only problem with is that how would the pets end up owning the assets? Hence, because bank will ask for Aadhaar card and all, so then you'll have to take the dog for all of that. So better make a pets trust where you create a trust where the beneficiary is the pet and the trustees are the one getting the property. So that would be a better course rather than making the pets beneficiaries. In fact, Mr. Ratan Tata's will, I think, has created a trust for the stray dogs in Bombay house and in his house, his dog. And then he's appointed a guardian for the pets. Then the guardian would be getting the estate to take care of the pets. That is a different story. But if you just name the beneficiary as the pet or the cat, then you have a problem. Who is an executor? Executor is one putting the will into motion, like your directors in a company or your partners in a partnership firm. Executor is the one who puts and executes the will. No criteria laid down in the law, but should be someone close to the testator, relatively younger than the testator, because if executor is older and he passes away first, then will be without an executor, then court will have to appoint an administrator. Better to check with him. Many people name somebody as executor and they don't even tell that person. Then afterwards, when the will is opened, they say, you are the executor. He says, I don't want to be executor. Then you will have a problem. What are his duties? Provide for funeral expenses, pay off debts, and if will needs to be probated, he is the one who has to get the formalities done. Witness, you need 2 witnesses. What do the witness need to witness? They need to see and certify that this person is signed in our presence. They don't need to certify or they don't need to know what are the contents of the will. You do not need to show the witnesses that. You just need to sign in their presence. All that the will says is that so and so has signed the will in my presence. That's it. Who should be a witness? It could be anyone. But generally if there is a dispute, the witnesses would be cross-verified. So always better to have respectable people rather than to have just house help who may not be able to withstand cross-examination. So generally people prefer chartered accountants, lawyers, close friends. Doctors are generally reluctant to act as witnesses. So they will say, I'll give you a medical certificate of fitness, but I don't want to be a witness. Unless he's a close friend, GP kind of a thing, then it's a different story. I had a very interesting case where a client came. He kept his GP as the witness. So he signed on 1st November. And then, how doctors are, give it to me, I'll sign it and give it back to you. Doctor signed as witness and wrote the date next day, 2nd November. Now nobody noticed it. Matter after the person passed away came up for probate and judge saw and said, what is this? This is 1st November, this is 2nd November. What is this? And the whole thing was treated as a fraudulent will, and then it went as per intestate succession and everything fell flat. So you have to be very careful in documentation. Pay attention to every line, every page, every signature, every date. Cross-verify. Normally when there are long wills, on 2nd page it is written, I leave everything to my wife. And 7th page it will come, I leave half to my son and half to my wife. Which will apply? Then courts will say there is ambiguity in the will. Then each judge will take their own view. So read it multiple times. See every line. Otherwise you will end up making mistakes. And that is where DIY, do-it-yourself approaches, downloads from Google, all that does not help. Please invest some money and educate your clients also. Invest money, go to a professional and make a professional will. Otherwise you will end up in these small problems somewhere. I'm not saying it's always the case, but usually I've seen DIY fails. Can a beneficiary be a witness? Answer is yes and no. If it is a non-Hindu, beneficiary cannot be a witness. If it is a Hindu, Jain, Sikh or Buddhist, beneficiary can be a witness. That's how the law is. It distinguishes based on religion. Is it advisable for a beneficiary to be a witness? No. Even for a Hindu, I would say better not, because then there is a clear cut of conflict of interest. Then the court may look upon it that because he was getting a gift, that this witness could be a doubtful category. So try and avoid beneficiary being a witness. What if testamentary capacity is doubtful? I had a case where client was 94 years old and he wanted to make a will. Now, it could always be challenged that he was under undue influence, he did not understand. So we got not a doctor's certificate, we got a neurophysician certificate from a very reliable hospital in Mumbai. And the neurologist put him through a series of tests. In 2 minutes, tell me 5 things which start with the letter P. It was like an IIM Ahmedabad aptitude test. And he gave him a question paper, he gave him an answer sheet, and along with the certificate, he attached the question paper and answer sheet and the grading system. That matter came up for probate petition, and judge said, look at the mental capacity, amazing mental fitness, will upheld. So, if in doubt, get a proper certificate. Do not go to a GP. With due respect to general practitioners, it is not their subject to comment on mental capacity. Invest in a neurologist or a psychiatrist fees and go to the right one if the stakes are very high or if the testamentary capacity is in doubt. We looked at doctor's certificate, so I wouldn't deal with that. Top 10 myths when it comes to a will. Will must be on a stamp paper. No, it can be handwritten on a plain paper also. There is no legal format for making a will as long as it is legible and there is no ambiguity. Wills once made can be changed n number of times. Wills take effect only after a person dies. Till then, it's ambulatory. Wills can exclude everything, everyone, and give everything to charity. But if you are excluding 1 or 2 people, always give reasons why. It will help when the matter goes into dispute. That I have not made my brother a beneficiary because I have provided for him or whatever. Explain it, it will help. Will has to be dated because the last will prevails. Nomination does not prevail over the will, it is vice versa. All women can make wills whether married or unmarried. 2 witnesses are a must, and marriage revokes a will. Now again, yes and no. For Hindus, marriage does not revoke the will. For non-Hindus, marriage revokes the will. So when a Christian lady gets married, if she has made a will before marriage, unless she makes a new will, her old will lapses and she will be treated as dying without a valid will. But if a Hindu male has made a will before marriage and he gets married, then he does not need to make a new will. Same for a Hindu female. So Hindu, Jain, Sikh, Buddhist, they don't need to make new wills. Anybody else need to make new wills. Joint wills and mutual wills, these are very peculiar concepts which generally should be avoided. Joint wills means husband-wife making a joint will in one will and they lay down what happens. So first everything goes to wife says everything goes to husband. If we both are not there, it goes to our children or it goes to charity or it goes to XYZ. So that lays down the distribution mechanism. Mutual will is exactly similar, but it is based on the concept that we have entered into a series of promises and hence it has to go in this way. If we want to change it, both of us have to come together and we have to change it. Now when are mutual wills preferred? When either party is in doubt that after me, he or she may remarry and then the new spouse will get my property. So therefore, we have made a mutual series of promises and that decides the way in which we want to lay down the waterfall mechanism. I generally don't suggest making mutual wills because they're very cumbersome when it comes to probate and other petitions. However, if there are specific circumstances, then you can have mutual wills. Otherwise, mirror wills are the best. Husband making for wife, wife making in his favor. If both not there, it goes as per they have what decided. Special issues, wills for people who are physically or visually or mentally challenged, who are autistic, who are schizophrenic. Here, mention the exact nature of the disability of the relative. Provide for a guardian or caretaker for such a child. And better case would be to have a trust for such a child because then you would have a more permanent structure to take care of him or her. Life interest beneficiary, normally done where the surviving spouse has the right to reside in the house, but the asset immediately goes to the children. So you provide that after me, immediately my son and daughter will become owners of the property. However, their mother has a right of residence in her lifetime. You cannot throw her out in her lifetime, and she has a right to reside. So that's called a life interest beneficiary. Tenanted property, you can make a will for tenanted property unless the State Rent Control Act provides otherwise. In Mumbai, we have the Maharashtra Rent Control Act which says you cannot make a will for tenanted property. It goes as per the family members living with the tenant at the time of his demise. I don't think, do you have a Gujarat Rent Control Act? No. So then you can make a will for tenanted property and it can be bequeathed as per the tenancy laws of the state or as per the will, whichever is applicable. Registration of will, you can register with the sub-registrar of assurances. It is not compulsory to register a will. What does registration help in? It helps prove the genuineness of the will. It helps prove that there is no forgery. It helps prove that there was no coercion at that point of time when the person made the will. It does not mean that the will can never be challenged. It does not mean that the will cannot be altered. Will can be amended by an unregistered will after a registered will is made. So you can go home and make a new will which is unregistered and that will supersede. If there is a dispute, probate will be required even for a registered will. So registration does not take away anything other than help prove the fact that there is no forgery. Probate. Lot of questions on what is probate, why is it needed, whether it is compulsory, especially in Ahmedabad. It's a copy of a will certified by a court seal that this is final. Now nothing needs to be done. What the will says is end of the matter. No claims can be raised about the genuineness of the will. Now, application needs to be made to the local court. Like in Mumbai, you need to make it to the Bombay High Court. And you need to pay court fees. In Bombay, it's 3% of the value of estate, not exceeding 75,000 rupees. So there's a cap of 75,000 rupees. The witnesses and the executor will have to testify in front of the notary or the court registrar that yes, this is our signature. General notice to public will be issued that will of so and so deceased person has been taken up for probate. If anybody has any objections, please apply to the court. If there is no objection, the probate will be granted. Is it mandatory? Again, answer is yes and no. If the deceased was living in the cities of Chennai, Kolkata or Mumbai, probate is mandatory. If the deceased, and he's a Hindu living in these three places. If the deceased was a Hindu living in any other city, say in Ahmedabad, but he has an immovable property in Chennai, Kolkata or Mumbai, probate is mandatory. If the deceased is a Parsi living in Chennai, Kolkata and Mumbai, probate is mandatory. But if there is any other category, probate is not mandatory. So if there is a deceased in Ahmedabad who has no property in these three places, no probate required. If the deceased is someone in Delhi who has no property in these three places, no probate required. If the deceased is a Christian living in Chennai, Kolkata or Mumbai, no probate required. So based on religion, based on location, the Indian Succession Act has come out with when or no probate is required. But if the deceased is a Hindu living in Ahmedabad and there is a dispute of his will, then of course probate is required. Because then the only way to settle the dispute would be to go to court. In addition, banks, depositories, registrars, depending on their whims and fancies, have come up with laws that probate is required. Now they are a law unto themselves. I was just discussing earlier with Ashwin Bhai, that in spite of the Gujarat High Court saying probate is not required, different asset forums have come out with their own laws. NSDL has their own law. Cooperative societies may require a probate. What do you do in such a case? I think the only option would be to file a contempt of court petition and say, look here, this is the decision which says probate is not required. The deceased did not have any property in Chennai, Kolkata or Mumbai. Under which law are you requiring me to get a probate? Please answer that and say how this decision will apply. That would be the only way in which they would fall in line. Otherwise, you cannot argue with an institution and you'd just be wasting time and money on that. But this is the law, that probate not required in these three, other than these three places, if there is no challenge to the law.
Do you have that citation of the Gujarat High?
Not handy. So we looked at how you have a probate petition. How do you challenge a will? Somebody has come out with a will and you want to challenge it. So you file a suit before the relevant court where the will is coming up for this thing. Court issues notice to the defendants. Defendant then files his written statement. Plaintiffs submit evidence as to why they believe their will is final, or why they believe the earlier will is forged, or why they believe the earlier will is invalid. Court would then examine, cross-examine and deliver the verdict. Some cases what happens is the moment a person dies, the legal heirs will file, one of the legal heirs will file a caveat before the court. What does a caveat mean? Caveat means this will, if it comes up for hearing or for probate, you will not hear it or not pass an order without giving me a chance of doing it. So I have put my foot in the door even before the probate petition has come. So that often happens in many of these large business families. The moment the patriarch dies, one son will go and file a caveat. So nobody will be then able to pass the will without him being heard. That means dispute is going to come up for him. So that's called a caveat petition. Can a will have an arbitration clause? Can you say that if there is a dispute between the beneficiaries and the executor, then my friend or such and such person will become the arbitrator? Supreme Court has in a very categorical decision said no. Because arbitration is a contract between two people saying that look here, we are fighting, let's refer the matter here. Will was a unilateral act by the testator. The beneficiaries did not enter into a contract with him. The executor did not enter into a contract with him. So now you cannot say that if you guys fight, refer it to arbitration. No, that won't work. Only way would be to go to court. Court is the forum for that. New developments, video will, you all are recording my talk. Same way I could be reading out my will and the whole thing then comes on video. But now in the era, this was done for AIs and deepfakes. What happens if there is an AI deepfake video made of me reading out my will? So that's a problem. This was not envisaged when AI was not yet on the scene. Digital will bequeathing passwords to email, social media accounts, online bank accounts, e-records, digital data, crypto. There's a famous case of a person who had $500 million in a crypto wallet and he died and nobody knows the password. So the legal heirs know that he had money there, but they are not getting access because there is no password. And the wallet is saying, how do I know that you guys are the correct legal heirs? So matter has gone in limbo. So if you have digital assets, please take care of putting the passwords also somewhere. Otherwise, you will have a real problem left behind. Organ donation, which is now a trend and a very noble cause, should not be under the will, because will is normally opened after a person is dead and formalities are over. So if you want to do organ donation, have a separate set of instructions. Social customs will, very common, that I don't want a full-blown 12-day mourning period. I don't want this, I don't want that. Do not keep it under the will, make it as a separate will. Otherwise, that too will be opened much later. If you have global assets in the era of LRS, should I make one will for all my global assets? Or should I make a will separate for India, separate for UAE, separate for US? The better course would be to have separate wills for different jurisdictions. Having one common will for all jurisdictions is not a good idea, because each jurisdiction comes with its own set of problems, have their own probate petition, have their own formalities. And if you make one common will which may require probate, say in California, they charge probate fees on the global estate. So do not make the mistake of having one will, always have a separate will, and you can have cross linkages. You may say, this is my will for my Singaporean assets, I have made a separate will for my other assets. This is the will for my Indian assets, I have made a separate will for my global assets. That much you should do. So your legal heirs know that there is some global will lurking somewhere, but do not make one will for everything. Coming to trusts, why have trusts? They are useful if beneficiaries are minors, visually challenged, mentally challenged, pets, people who cannot take care of themselves. So you are keeping a trust mechanism so that somebody can take care of it, somebody can handle it, somebody is in charge of it. Complete control during lifetime and after death also, because the trust deed can lay down various mechanisms, trust deed can lay down various waterfall situations. No probate required like in the case of a will. So trust is done during a person's lifetime, so you don't need probate. However, if you create a trust under a will, then probate would be required. So trust under a will and living trust, there are two different ways in creating a trust. It reduces succession disputes because you're doing it in your lifetime, no case of probate, and it may help avoid estate duty if and when it comes. I would not use this as the main cause of creating a trust, but this is an incidental benefit. Incidentally, every December to January you will hear estate duty is coming. So that's the circus created by few friends in the profession, but I would not go by that. And I would not treat that as the raison d'etre for creating a trust. But if it does come, it's an added advantage. Wills take effect on death of a person. Trust generally on lifetime, but if it is trust under a will, then again it will be on death of a person. Probates, disputes, litigations, parts and parcel of wills, not so in the case of trust. Control after death, not possible in a will, possible in case of trust because you can decide the trustee mechanism, lot of conditions. Possible during lifetime, can you have a will during your lifetime? No. Will is effective only after a person dies. Trust can be on lifetime. Estate duty we looked at. Wealth planning for minors, pets, unborn children, all that can be taken care of by a trust. A trust is a private trust under the Indian Trust Act 1882. It is not a public charitable trust. It is not a trust eligible for 80G and 1112 benefits under the Income Tax Act. It is not a trust which would be registered under the Maharashtra Public Trust Act or the Gujarat Public Trust Act. Those are charitable trusts. This is a private trust. So there is a fundamental difference. whenever you go to open a bank account for a private trust, they will ask you what is the Darpan registration. This is for an NGO trust. I'm not an NGO trust, I'm a family trust. I recently had this run-in with one of the PSU bank's general manager. He said, how can you have private trust? Which law? So I said, under Indian Trust Act. He's saying, but who is the registering authority? Who is the incorporating authority? There is no incorporating authority. There is no MCA equivalent, or there is no ROF equivalent, or there is no charity commissioner equivalent for a private trust. It is a contractual obligation. Registration is not mandatory. Registration is optional. Only if the trust deed is getting a gift, means under the trust deed you are gifting immovable property, only then would you need registration. Trust can own any property under the sun. It can own flats, offices, shares, security, bullion, jewelry, gold, art, sculptures, but it cannot own foreign assets. Because under FEMA, a private family trust cannot make an outbound investment. So trust cannot do LRS, trust cannot make overseas investment, trust cannot own any asset abroad if it is a private trust. If it was a charitable trust, society's registration, they can do, but private trust cannot. Advisable for minors, unborn family members. You can say my son's future children or my daughter's future children will become beneficiaries from the date of their birth. Married daughters, very important planning tool in the case of daughters getting married. If you want against alimony protection, or if you want to ring fence it from husband's creditors, then you set up a trust for her benefit and for her children. Handicapped relatives, mentally unstable, pets we've looked at. So all of them, trust is a very good planning mechanism. To broadly put it, there are three parties in a trust deed: settlor, trustee, and beneficiary. Settlor, as the name suggests, is the one who settles the trust. In America, it is known as the grantor. In India and in UK common law, we know it as a settlor. So he's the one who executes the deed. He's the one who puts the property. He's the one who puts the starting point. You can have more than one settlor also. You can have co-settlers. Anybody who settles property, whether under the deed or even afterwards, is a settlor. Trustee, as the name suggests, is someone who is trusted. And trust always depends upon trust. If there is no trust, there is no trust. So I always tell people say, who do I keep as trustee? I don't trust anyone. I say, then you can't have trust. Because if you don't trust, how will you have a trust? So the name says it all. So anybody can be a trustee. It could be a friend, it could be a close confidant, it could be a family member, it could be a chartered accountant. Most common persons to act as trustees are CAs, because we are their first port of call, and that is someone who they have faith in. So they may use, or they may approach you to be a trustee. Lawyers, generally they don't prefer to be trustees, because they would be more interested in the litigation arising after that. So then like, if I'm a trustee, then how will I fight this case? So I don't want to be a trustee. Beneficiary, for whose benefit you are creating the trust. If there is no beneficiary, there is no trust. You must have two factors: property, even 1 rupee, and a beneficiary. I can create this. This is my property I'm putting in trust. I can create a trust for my family. Until this bottle exists, the trust exists. The moment this is gone, there is no trust. Because if there is no asset, what are you creating the trust for? If there is no beneficiary, supposing I have named 3 people and all 3 people die, trust comes to an end. And if you have not provided a charity or anything else, the trust comes to an end, property goes back to the settlor. So that is how a trust is created. Trust could be of 2 types: specific and discretionary. Specific means the shares are laid down, that we have 4 of us, each of us has a 25% share. So that's a specific trust. Discretionary, we have 4 of us. Trustees can decide who gets what. I may get 100, he may get nothing, or we all may get 25, we may get 50, 20, 10, 5, we may get 0, 1, 2, in any proportion the trustees decide. That is called discretionary. Discretion could be as to income, as to corpus, or as to both. So you may decide, you may say income is specific, corpus is discretionary. Income is discretionary, corpus is specific, income and corpus both are discretionary. In either of the 3 cases, the trust will be treated as discretionary. Trust can own immovable property, land, building, bungalow, flat, everything. It can open a bank account in its own name. It can have a PAN in its own name, and PAN is always given with a T in it. So unfortunately, because of that T, it is now the return has to be filed in the status of ITR 5 or 7 only. In an earlier version of the income tax system, a representation was made by BCA to the CBDT, and they allowed you to file ITR 2 as individual, which is the correct legal position. Supreme Court has very clearly said a trust created for individual beneficiaries is an individual. BCA had made a representation to then Principal CIT. She approached CBDT and they changed the portal, and we were filing in ITR 2. Now, ever since the new portal has come, it is back to ITR 7, and they are not understanding at all. So, whether you like it or not, whether you are a private trust or a charitable trust, you have to follow ITR 7, and the T in the PAN creates all the headache. Trust cannot open a Demat account in the name of the trust. Now, this is because of SEBI's Act. But it will be opened in the name of the trustees, and the Demat account will be linked to the PAN of the trust. So when you get the master client account of the Demat statement, check the PAN linkage. It should not be linked to the personal PANs of the trustee. Otherwise, it becomes their personal property. You must check that it is linked to the T PAN number. Then you are in safe hands. It can own mutual fund units also. Now, if you want to transfer any assets to the trust for a bungalow or a flat, you would need a gift deed which is registered, and stamp duty is paid on the jantri value of the property in Ahmedabad. So whatever is the jantri value, based on that, you create a gift deed and you gift the property to the trust, and the trust, that gift deed needs to be registered with the sub-registrar of assurance. But if it is movable property, like money, you just need to write a check. If it is shares, you need to do an off-market transfer of a Demat slip, delivery instruction slip, and in the name of the Demat account of the trust. Paintings, art, something like this, just do it by delivery and possession. You don't need to have a gift deed. If you make a gift deed, you will end up paying stamp duty on it as applicable in the local law. So that's 3.5% in Ahmedabad. But if you don't make a gift deed, there is no stamp duty required in case of movable property. If there are listed shares which you want to transfer by the promoters to the trust, you need to bear in mind the implications of the takeover code. So whenever the promoter is transferring his stake to the trust, you would have to look at the takeover code implication. SEBI has come out with a white paper and has laid down that if any promoter wants to come to us for exemption, we will grant automatic exemption on an application being made, provided certain conditions are met. All the trustees are individuals. We don't want any corporate trustee. Beneficiaries and settlers are family members or their relatives, and certain clauses are laid down in the trust deed, then we will automatically grant you an exemption. And SEBI has been granting it. So whenever listed shares are being gifted to trust, bear in mind the takeover code compliance. Foreign beneficiaries in a trust, no express clarity in FEMA. There are different views being taken. I believe you can make foreign beneficiaries a resident, foreign residents a beneficiary in a trust in India. However, there is a little bit of ambiguity going on how can you gift the assets from the trust to the beneficiary, whether it would be $250,000, whether it would be $1 million equivalent per year. What happens? There's a lot of ifs and buts. Can a foreign trust be set up by a resident settler? There is no express prohibition or permission, but under LRS, under using the $250,000 route, he can set up a trust for non-resident beneficiaries. If he sets up for relatives who are residents, then LRS prohibits a resident from gifting any money directly or indirectly to the credit of another resident. So one resident cannot make a gift abroad for the credit of another resident. Hence, he cannot set up a trust for resident relatives, but if it is for non-resident relatives, say a person living in the city of Ahmedabad, his son's family or daughter's family is in the US, he can set up a trust in US for their benefit, keep sending $250,000 every year. That should be possible. Gifts and release deed. Gifts are very popular way of transferring property within the family. So, you have family members, you have different conflicting claims. Somebody makes a gift to somebody, somebody releases his share in a case. It is from a donor to a donee. Donor is the transferor and donee is the transferee. It is voluntarily and made without consideration. Now, gift deed, if it is for immovable property, it needs to be stamped and registered. If it is for movable property, it can be made by delivery and possession, no need for stamp duty or registration. And what would be the stamp duty on a gift deed? Whatever is the duty applicable on a conveyance. Can gifts once made be taken back? This has become very popular nowadays. Parents make gifts and say, children do not take care of me, I want my property back. The Supreme Court gave an analogy of a fired bullet. Once you fire a bullet from a gun, you cannot retrieve it. It's a one-way street. Unless you made the gift conditional. So if you put a condition subsequent that I am gifting this property to my son only if he takes care of me, only if they maintain me, and then they do not, you could go to court and claim the property back. Otherwise, even under the Protection of Senior Citizens Act 2007, Supreme Court has said, no, you cannot say, I am a senior citizen, I gifted property to my son, he is not taking care of me, please give it back to me. No, you made a gift, you voluntarily parted possession with it. Now there is no concept of taking it back. You must have a clause for taking it back or reserve a right of life interest for the donor. This is something which is very popular. So in one case, I had a 96-year-old gentleman who wanted to gift his flat to his grandson. But he said, till I am alive, I have the right of residence in my bedroom. You cannot even displace me from this bedroom. So, master bedroom belongs to me till I am alive. He lived for 4 years after the gift. But in those 4 years, you cannot displace me. Only condition would be if the building goes in for redevelopment, which is not in your control, then you will ensure that you get me a property on rent or whatever in a good locality, and he laid down the localities also. Then only, you can't tomorrow put me in some obscure place and say, look here, now I've given you one bedroom, please enjoy your life there. No. So that's called reserving right of life interest. That is valid. There was a very important Supreme Court decision in Rajamma where the Supreme Court upheld the right of life interest beneficiary. We looked at the stamp duty implications. Release deed, very popular in family-owned properties. So 2 or 3 co-owners, one of them wants to get out. It's called a release deed. He releases his share in favor of the other co-owners. This is popular, why in some places like Maharashtra? Because it has a concessional stamp duty as opposed to a gift deed. In a place like Gujarat, it does not matter because the Gujarat Stamp Act does not have a concessional duty on release deed as opposed to a gift deed. In Maharashtra, if it is ancestral property and it is a release from one co-owner in favor of his relative co-owners, the duty is only 500 as opposed to 4% of the market value of the property. So there's a huge saving in stamp duty. Therefore, everybody wants to say it is release deed. Everybody wants to say it is ancestral. Ancestral means it has to be coming from your ancestors. You cannot just buy a property, father bought it and say it is ancestral property. No, that would not work. It has to be ancestral as understood in law. What is ancestral property? Property received from sons. There was one case in Punjab where they said, father is saying it's ancestral because I got it from my sons. So they say it can be 3 levels up, it can be 3 levels down also. So court said, no, ancestral has to be one way. Property inherited by a male from father, grandfather, great-grandfather. That is generally what they treat as ancestral property. Now if all fails and you are unable to arrive at a settlement, then we go in for a family settlement. What is a family settlement? It is an arrangement between members of the same family for the benefit of the family. So they say instead of spilling bad blood, litigation, court, let us all come together, arrive at and hammer out a solution, and we sit across the table and say, okay, you get this, I get this, and if there is a difference between what you got and I got, one of us will pay the other and top up and equalize the balance. That's called a family settlement, something which has been very common in India. Earlier it used to be done by the panchayat. The panch would sit and sarpanch and the panchayat would say, okay, don't fight. This is how the lands will be divided. This Haveli goes to you, this property goes to you, end of matter. If you cannot arrive at a family settlement, the only way would be to go to court. But very important, it must be bona fide to resolve disputes and rival claims by a fair and equitable division of property. It can be oral also. We can sit across and say, okay, you get this, I get this, fine. Even future potential disputes may be covered. Today you may not be fighting, but you are saying, look here now, second and third generation has come into business. I fear that they will not have the bandwidth which we have today. They may not have the relationship which two brothers have. So why should we wait for them to fight? Let's quell any potential disputes and go in for a family settlement. Courts generally lean in favor of family arrangements. It is essential that it is valid. Otherwise, even income tax can question it, and they may apply KARTA. There have been 2 cases where income tax has questioned it and said that no, this is not a valid family arrangement. This is just a device to avoid paying capital gains, and therefore family arrangement concept was set aside. Entire law is case law based. There is no act dealing with family settlement. That is the beauty of this term. Now where you will find the term family settlement, it comes from case law, and there are various Supreme Court and High Court decisions upholding the law. Courts would make every principle and every policy to uphold family settlement. And what is family for this purpose? Is it just father, son, daughter, wife? No, it is a very broad, even cousins, uncles, second cousins, all of them are treated in the purview of family. So courts have given a very wide description of family. All those who are related by blood or marriage. Very wide. Family settlement is not a transfer. That's the most important provision to bear in mind from a taxation perspective. So no capital gains, because it is not a transfer. Therefore 247 does not come into play, therefore 45 does not come into play, and therefore capital gains does not arise. Even married daughters can be made party to family settlement, but if provided she has signed the MOU. In one case she had not signed the MOU, but they said she is a party. They said no, that's not enough. She has to be a signatory. Married Hindu female can execute a family settlement with her father's heirs. This was a dispute which arose about 3 years ago, which went to the Supreme Court, where the case was that a lady settled with her cousins, that was her uncle's children, father's brother's children, and the plea raised by other people was, how can she settle? She's married, she's no longer a part of this family, how can she be party to family settlement? So Supreme Court said she remains her father's daughter even if she is married, and therefore she can enter into a family settlement. Can companies be made a party to family settlement? Here the courts have said no. Companies cannot be made. There is this Bombay High Court decision in BA Mohta Textiles where they have said family settlement means there must be a family. Company is not a family. The persons behind the company may be family members, but that does not mean they can be party to the family settlement. So that is one important principle. No capital gains tax arises. However, the law is not that clear when it comes to the applicability of 56(2)(10) on the recipient of the asset or the property. If the recipient is not a relative as defined under the explanation to 56(2)(10). I believe it should not apply because family settlement is not for without consideration or not for inadequate consideration. There is consideration. Consideration does not always need to be in the form of cash or kind. It is in the form of giving up of disputes. It is in the form of buying peace. It is in the form of maintaining harmony within the family. That is your consideration under the family settlement agreement, and therefore 56(2)(10) should not apply. I think there was a Mumbai tribunal decision in Paras Gundecha which has taken a similar view that family settlement does not attract 56(2)(10). No registration required. Even if immovable property is changing hand, you can have an oral family settlement which is then made into a memorandum of family settlement, and only the terms are recorded and no registration required. No stamp duty should be applicable. However, if the agreement itself brings about the family settlement, then registration and stamp duty will be required. So there's a very thin line between that. Practical experience, many registrars do not approve for transferring property merely on the basis of family settlement. because they do not want to forego the stamp duty registration fees, and that is why they wrongly say we will not transfer the property. If you want, you get a court order in favor of that. It's similar to your probate issues. You have a very unique act in the Hindu Gains of Learning 1930. So if an education of a family member, say somebody did a CA and his education was funded from HUF funds, can the family now get up and say, look here, we educated you, therefore all your practice earnings, we have a part in that. Please pay us a share in that. So that was the law earlier, prior to 1930. And that's when the Hindu Gains of Learning Act came into force, which says that any gains of a learning of a co-partner are his exclusive and separate property. Even if learning was funded by HUF, income earned by him by virtue of his skill, knowledge, learning solely belong to him. Acquisition of property from his such learnings are his personal property and not that of the HUF. HUF has no right title of interest in such terms. And Supreme Court in Chandrakant Manilal Shah said term learning is very wide and encompassed every acquired capacity which he has to pursue any trade, industry, profession or vocation. It need not just be business, it even includes profession and vocation. Also, bear in mind when we are talking about estate planning, Married Women's Policy Act. Now, if you get an MWPA policy, it's an insurance policy brought under this in the name of the husband, where beneficiaries are wife and or children, then it is deemed to be a trust for them and creditors of the husband cannot attach these assets at all. Because what the law says is no matter how bad the husband is doing in business, he must provide for. He is legally bound to provide for his wife and kids, and an MWPA policy in his name for the benefit of his wife and kids is insulated from the creditors. It's an asset protection strategy. However, you need to have it clearly mentioned on the policy that this is an MWPA policy. I believe it is relevant even today under the Insolvency and Bankruptcy Code, although to the best of my knowledge, none of the decisions have tested it on the anvil of MWPA, but I think it could survive that also. Guardianship of Hindu minors, we have the Hindu Minority and Guardianship Act, which deal with the powers and duties of guardians. Natural guardians are father, and if there is no father, mother. If there is no father and mother, then guardian would be appointed by court, or the parents have the power to appoint a guardian under their will. So generally in the case of parents preparing wills, if they have minor children, they would lay down that if my wife and I both are not there, then after us the guardian for our kids would be so and so. Because otherwise then the guardian will be appointed by court. Now, what is the relevance of this act? If you bequeath or if you give any property to a Hindu minor, immovable property, you cannot sell it without prior permission of the High Court. So that becomes a major roadblock to any property owned by the minor, even if it is for his benefit. If a property of 5 crores is going for 5,000 crores, you may say, how is the minor losing out? He is earning so much. Court says, no, minor cannot enter into a covenant. Minor cannot enter into a contract. How does he know 5,000 is beneficial and not 5,100? So come to court, get my permission, only then will I allow you to sell the property. So this becomes a big roadblock. So always be sure if you are putting any property in the name of a minor, you would need prior permission of the court under the Hindu Minority Act. What if immovable property belongs to HUF and minor is one of the co-parts? Then do you need permission? Answer is no. However, having said that, there are some lawyers who out of over enthusiasm say Hindu Minority Act will apply to such a case, go and get a permission from court. Then it depends on who has a greater need, the buyer or the seller. If the seller has a greater need, then he has no option either to agree or they use this as a bargaining tool to reduce the price. So there's a Supreme Court decision in Balaji's case. KARTA has the right to dispose of or alienate HUF property even if a minor has an undivided interest. Reason is that HUF is capable of acting through its KARTA or adult member. Sons or minor members need not be consenting party. It was very clear, yet people are ignoring it conveniently. the Hindu Adoption and Maintenance Act 1956, we looked at that a stepchild cannot be a legal heir. Can an adopted child be a legal heir? Answer is yes. Adopted child severs all ties with his biological parents. If there is a valid adoption, he or she becomes the child of the adopted parent and not that of the biological parent. Now, here it's a very interesting law. Hindu male can only adopt with his wife's consent. So a Hindu male who is married cannot adopt without his wife's consent, and without consent it is void adoption. He can adopt either a son or a daughter. Prior to 1956, only sons could be adopted. You could not adopt a daughter. Then Hindu law got codified, and now you can adopt a daughter also. Hindu female can adopt only if she is a widowed, unmarried or divorced. A married Hindu lady cannot adopt even with her husband's consent. The Bombay High Court has said that she cannot adopt even with her husband's consent. She either has to be unmarried, divorced or widowed. Now again, a very silly way of looking at things, but this is how the law has laid it down. The child being adopted must be below 15 years of age. So if it is above 15, you cannot adopt a child. On adoption, he or she severs ties with his biological family, and he or she is not deprived of the estate which is vested in him of that of the biological parents prior to adoption. If it happens post-adoption, he is no longer their child. And he now becomes entitled to inherit properties of his adoptive parents. So here you have the Supreme Court's decision in Chandan Bilasani, which says that adopted child deemed to be a child of the adoptive parents from the date of adoption, and from such date he would now be entitled to succeed to the family member's estate of his adoptive parents. These are some interesting facets in succession law which are not directly related but nevertheless important. In the Delhi High Court decision, there was a case of whether a son has a right to reside in his parents'. So the house was owned by the father, belonging to him. His married son and his family were living in it, and they were not getting along. The father intended to ask the son's family to leave the house, and they went to court saying, we have a vested right, we cannot be thrown out. Court said, you have no vested right to remain. Your father has no obligation to maintain you. You are a major, you are married, you have your earning, or even if you don't have your earning, it's your bad luck. Your father can ask you to leave. You have no vested right to remain in your father's house. So they can take away this right if relationships are no longer cordial. The only course for the parents would be either they go to police station to ask them to evict. In this case, the police did not cooperate, so they had to go to court. But there are many decisions on this kind of a provision. We often come across the concept of lineal, ascendant and descendant. It's there in 56(2)(10) also. But this is a provision which is not defined in any law at all. What do you mean by that? Lineal means a straight line. It does not go diagonal, does not go horizontal, does not go left, right, center. It just goes up or down. Ascendant means up, descendant means down. So if there is a straight line in the family, son, father, grandfather, son, grandson, great-grandson, that is lineal. Would it even include women? Would it be daughter, mother, grandmother? Would it be a combination, son, mother, grandmother? Yes. It has nothing to do with male or female. It is only straight. What if in between somewhere there are adopted children? Is it then lineal? So there was an estate duty decision of 1926 by the Rajasthan High Court where they said yes, because from adoption, adopted child is put at par with the biological child. So why should it not be part of the linearity? But do not include cousins, uncles, nephews. All of them would not be part of the linearity. You will be interested to know there are 11 laws in the country which define relative, and each of them defines them in a separate way. Income Tax Act 56(2)(10), Companies Act most restrictive, stamp duties of various laws of various cities, Insolvency and Bankruptcy Code. FEMA has now taken the Companies Act definition, but for one purpose they have taken the definition from FCI, so which relies on the Companies Act 1956 definition. Rent Act in Maharashtra uses the term family, so that is totally different. India's related party uses again a different definition of relative. Prohibition of Benami Transaction Act has a different definition of relative. Agricultural laws of each state have their own definition of relative. SEBI comes out with a definition of immediate relative, so which is even different. It has relative and it has immediate relative. Insider trading has connected person, which is even a different definition of relative. So each law uses relative in their own relative meaning. Nobody defines the term heir. Legal heirs are used but not defined under any law. Everybody uses the term relative or family. Special Marriage Act. This is very relevant in the case of marriages taking place abroad. So you have a lot of destination weddings. You have a lot of weddings between intercaste people in India also. They need to get registered under the Special Marriage Act of 1925. So if a Hindu marries a Hindu under Special Marriage Act, everything is fine. But if a Hindu marries a non-Hindu, Hindu Succession Act application ceases. So then no class 1, class 2 agnate government. Then Indian Succession Act applies. He also ceases to be HUF member. That is a very harsh provision. And it changes the succession pattern not just for the couple, but even children born out of the wedlock. So all of them would now be governed by Indian Succession Act. There will be no concept of HUF for them. But for marriages between Hindus, Jain, Sikh, Buddhists, and registered under SMA, like a marriage taking place in Dubai, they would need to get registered under SMA. They continue to be Hindus, they continue to be members of their family, they continue to be, their children continue to be Hindus. This is very relevant when interfaith marriages are taking place with Christians or Muslims. Then they will not be, if two Muslims get married, registered their nikah under SMA, then Sharia law ceases to apply. They can make a will, they can be governed by the Indian Succession Act. So very, very fine line of distinction. And lastly, if a Hindu's daughter marries a non-Hindu and converts her religion, would she still inherit her father's property? Now, this is a very interesting decision and a issue which arose because there was this Caste Disabilities Removal Act of 1857. It provided that conversion of religion was not a ground for forfeiture of property and exclusion of inheritance, but this act was repealed by the present government in 2017. Now, what happens after that? And what is the position of her children who are now not Hindus? Can they succeed to their maternal grandfather's act? What it said is, she is a Hindu by birth and the father remains a Hindu. So even though she is no longer a Hindu post-marriage, father's estate will go as per Hindu Succession Act. It goes to his class 1 legal heir. Class 1 says daughter. It does not distinguish whether daughter is Hindu, Muslim, Christian or whichever religion. Therefore, she continues to be entitled to succeed to her father's estate. Her conversion has no role to play in her succeeding to her father or mother's estate. Would she be part of father's HUF if her marriage is registered under Special Marriage Act? Here the answer is no, because now she has ceased to be a Hindu, so she cannot be a co-partner and she cannot be a party to her father's HUF post her marriage being converted and post her religion being converted. So these were very fine issues which the Bombay High Court and the Gujarat High Court recently considered. And I felt in the era of interfaith marriages, it's going to become even more and more popular and relevant going forward. Thank you very much, friends, for a patient hearing. We can now have questions.
So, 2 points again. 2 points. First, in case where you say that your view is when, in case of children of married daughter, they become the members of the group in the Nana's HUF. One point when we compare this with wife, she is a member of the family, but not the co-partner. In the same way, when a daughter gets married, she remains the co-partner, but she leaves the family and joins the family of her husband. So with that principle, can we not say? And if you can just one.
No, even though she is a member in her husband's HUF, she continues to remain a co-partner. That is exactly what the law is.
But she is not a member.
She will now become a co-partner. Therefore, her children will have an equal right.
And if you could please explain the difference between the taxability of the private discretionary trust and
That would require a separate session by itself.
You have to give time.
Time, yeah.
To come again. Maybe a very short.
So if it is a discretionary trust, it would be taxed at MMR. Every rupee of the trust would be taxed at MMR. Yeah. That's okay. I think every rupee of the trust will be taxed at MMR. And now MMR is 42.74%. Recently there is a tribunal decision, I think of the Ahmedabad tribunal or Chennai tribunal, just last week, which says that only if there is basic exemption then MMR applies. I don't think that is the right way to look at every rupee. If it is specific trust, then you divide the income in the shares and the beneficiaries pay tax.
Okay,
You have told that
Yes.
the trust created for the specific purpose, when that purpose solves, the property goes back to settler.
No, I said if there is no beneficiary in the trust, then the property will go back.
But if settler he has set the trust after his demise, then what about that property? What should be done?
Then you must say provide for an alternative. Like if no beneficiary, say it goes to charity, say it goes to ISKCON temple, or it goes
otherwise
to
that,
Swaminarayan temple. Somewhere somebody must be named. Otherwise, what will happen? Then government will come in.
Beneficiary has not a share in the property of the trust.
Beneficiary does have a right, depending on whether it's a discretionary or specific.
If it is right, then it will not go to my successor.
Depends if it is specific trust or discretionary.
If it is a discretionary trust,
Then you have no right.
discretion can be to the hands of the
No.
beneficiary.
No. You must provide that in the trust. Otherwise, you don't have a vested right.
In a joint property, you say, suppose I buy a property, 100% estate is mine, but I name my second name as my wife.
That is only name holder. She has no right in the property.
So in this particular question, as a co-owner, how do you reconcile it with the Transfer of Property Act?
So Transfer of Property Act says unless otherwise provided, when the shares are not clearly specified, they will be in proportion to the funds used for the purchase of the property. So in this case, it will be 100% belong
Can it
to
not be a
Section 52 of the Transfer of Property.
If it is joint name is my wife's name, can it not be said it is a different property by me to my wife?
No. You paid for it, so it's your property.
So regarding ancestral property, I need some clarity on ancestral property is one which passes through 4 generations and divides. 3 generations and divides. 4 generations it becomes undivided. On the other hand, there is this any property will become an absolute property either through inheritance, through a will, or through the succession. How do you reconcile the two? When will a property ever become
It should remain, once you get it, law is saying it is your own property.
So exactly. So how can a property stay ancestral?
It does not stay ancestral. It does not.
So can it be said that an HUF property can still stay an ancestral property?
HUF property can, but once it is partitioned and given to somebody, then it is his personal property.
After partition.
Unless it is specifically given to some HUF or something.
Yes, there is a difference.
Sir, whether a person can have a 2 different will for
No.
in India. So
No.
proper I hear more
No,
property.
no. You can have 2 different wills based on jurisdiction. I can have one for my Dubai assets and one for my India. I cannot have one for this house and one for that.
Someone that HNI clients, many clients are planning that as they don't want to disclose all the assets what they are having, so they basically in some of the cases they are, I think, so dividing that so to the registrar or to the property transfer details, they don't get every detail, so they are doing in piecemeal.
That's not correct.
Logic, so it's I'll watch on.
No.
Sir, in case of Heir, main member is already died. He has 2 daughters. Mumbai.
His daughter. Eldest daughter. Elder daughter. I told you banks are beyond my purview. My knowledge stops and they start. Yeah.
He cannot even say the same.
So you show them the Sujata versus Manu Gupta Delhi High Court decision.
Yes.
Unregistered will can be prepared.
Sorry, I didn't get it.
Unregistered will can be prepared. But at
the time of transferring the property, immovable property, municipality asks for the registered will or pedinamu.
So pedinamu is like a legal head certificate. So you get a legal head certificate.
When there is a will, how can you get a legal head certificate?
They just want to know who the legal heads are, which is wrong. But you know, everybody has come up with their own thing.
The party to a will can visit that they are legal. No.
Or you get a probate done.
So when we transfer a property in a will, it's written that this property goes to elder son. Okay. So even if it's mentioned in the will, so basically here the revenue record works. It goes to all the legal heirs. Then we need to take NOC from the other three.
That's true.
Yes, but it's going on practically,
Yeah.
and then you need there is no logic of doing will as such.
Absolutely. You're making
The purpose, the basic purpose gets.
Absolutely.
Revenue department does not
Understand
give
this.
any, that their stamp duty and all their own procedures only.
Sir, when in a will specifically it is written that the property should go to the particular person, then why pedinamu?
I agree. There's no logic behind it.
So that can
No
just
logic,
things be
but-
challenged.
Of course, you should be challenged.
Then again,
Like
need of HUF.
So say in case of registered will, if it is subsequently changed, whether is it required to have a registered will? Because
No.
the practical issue is with the court and any legal issue, then the court or any arbitrator also in case of, but in court also.
No, court, Delhi High Court, Andhra Pradesh High Court.
But then the question arises about the challenging of it. Somebody, the opponent party says that this subsequent will is a bogus will.
That would be the case. Even the registered will can be challenged that it was not properly, he was not mentally challenged up to it, etc. But registered will
For
can
the
be.
safety purpose, once it is registered once, then second will should have to be, I mean, it's advisable.
Advisable.
Yeah, it's advisable.
But you can have.
But why to create controversy? Once the first will
Yeah.
is registered, then second should have been registered.
But he may not want to do it. He may not feel like going and doing it. It's always doable.
No, but out of 10 cases, practically it is 8 cases. It is a forgery will,
Yeah.
subsequent will.
Then
Practically.
Then you will have to prove it. But the challenge will be on forgery, not on the fact that it is done.
Sir, nowadays, bank insists for the nomination. But if the amount is above 5 lakhs rupees, they ask for the pedinamu. Then what is the purpose of the nomination?
Yeah.
So they ask to bring the pedinamu.
Yeah.
In case of discretionary trust, if the settler becomes the beneficiary, so do we consider that as a revocable?
No. Only if settler, beneficiary, and trustee all are the same. Then,
In case of discretionary.
in any case.
Sir, you said about probate in Bombay. Sorry. Probate in Bombay.
In case of will, if the executor dies, what is the remedy?
Go to court to appoint an administrator.
Sir, you said about.
That's why I have an alternative.
You said about probate in Bombay when there is immovable property. So in Maharashtra or Bombay, when will is registered, I mean, any immovable property, after the death of any person, even if he has made the proper will, probate has to be.
Of course.
Of course.
Taking this thing a little bit further, supposing somebody has a immovable property in Pune, does it require probate?
Mumbai is separate.
Only Mumbai only.
In fact, now the view is that even if it is Thana or elsewhere, it don't need. I mean, I think that is splitting. But that's how the view is being taken.
Sir, can you throw some light on the legality of living will in India?
It's not. It's dead because living will is like an advanced medical directive where you would say that after me, when I do not have control over my mental faculty, when I'm in a state of coma, vegetative state, if I'm on the ventilator, how would I like the ventilator to be shut off? So, Supreme Court said in a country like India, if we give you facility for living will, relatives will automatically say this is living will and shut off the ventilator. So you have to get permission from the magistrate. The magistrate will appoint a medical board. They will give that opinion to the hospital. Only then living will become the fact. By the time they will implement the living will, the person would have died. So you can make a living will. The government was to come out with a bill sometime in 2007, which never saw the light of day. But nevertheless, make a living will for whatever it's worth. I think someday it may help. Yeah.
In case of a private trust, the author
trust is discretionary, but the income distribution is specific, then how will it be treated under the income tax act?
It's like discretionary.
And so, when the income is specific, then also it's
Sir, prevails over joint account and nomination.
Yes.
Then how it helps joint account or nomination?
I explained that on a person's demise, there is a phase for the society to deal with. Ultimately, it will go as per the will. Yeah.
So there is a private discretionary trust, and there is a specific way if the trust is removed, then there is a specific way that will contribute in a particular manner and on a particular time. Now, in the trustees cannot, it is mentioned that trustees cannot change this clause. Now, the sector is allowed, but they want to use that funds before the commission is whatever the commission is mentioned, not the high school type condition. They want to use that funds. Then what is the remedy for that?
They could only go to court to amend the.
Even though settler is allowed.
Yeah, settler is, unless it's a revocable trust. See, normally settler will relinquish all his power. It becomes irrevocable. Then settler has nothing to do. It's like a fired bullet. It's out of his hand. Then the trustees have to go to court.
Then if it is revocable, then
Then the settler has powers to do call it back and say I.
If the private trust does not say the end date, then enough 18 years.
Yeah, 18 years from the period of any child not in existence today.
Not from the date of settlement.
No. The rule against perpetuity says that if you are bequeathing something to an unborn child, then it cannot be beyond 18 years from the date of his minority. I mean, date of his birth.
Can the vesting date can be extended beyond 18 years?
Not beyond the date of perpetuity. And if you want to exceed beyond a date, then you may need to go to court.
When you say joint will, or mirror will, what would be better?
Mirror.
This is a separate way.
Yeah.
Some advocates are advising that when your wife's properties are only created by your efforts and your money to some extent, she has not been earning anything. So instead of having two separate wills, you should include all these things in your will.
That's her absolute property which she has got by way of gift. Into succession access, she can deal with it as she pleases. It's not your property. Unless it's a case like we mentioned where she's only a joint holder.
No, she is legitimate holder of some property.
Absolutely not.
Even though it's not
Absolutely.
there again, nothing like there are some people.
There's no clubbing
all
of
clients are asking
see,
like
there's
this.
not a concept of clubbing of income kind of. It's not like 64 where you club wife's income and your income is because it was gifted. There's no concept of clubbing of will. I would not say.
Sir, in case of the say rate where it is mentioned in name of the wife and husband is 50%, but not the payment which is made by the husband.
Then it's a gift from the husband to the wife.
After the name of the husband, 100%.
Just to elaborate further, where the wife's name is added just for the social as the tax calculation was
Yeah.
Needs to carve out and
See, in case of joint
Yeah.
Sir, if the property is gifted when the person is alive and then post his or her demise, can the legal challenge that ownership? Like only the whatever the
See, in case of joint name for sake of social security, that's a husband is the payer. Husband is a making for payment and is a super as tax is concerned, he is the owner of that property. For social security, he keeps his wife his name. But at the time of any sale or transfer, any time, the revenue is saying that is both of them are a 50-50%. And even buyer also makes some TDS on 50% as well. What is the so that it is required, advisable to have something mentioned in the document itself that it is owned by husband only for social security.
Always.
But advocates never do it.
They don't understand.
They don't
Revenue report they mention both the names, so it assumes that 50-50%.
That's the way you should provide. Yeah.
Normally, advocates are saying that it can be considered as a conditional will, and that's why when it goes to a challenge or it goes to probate before the court, then there can be a challenge. So, if you can provide any guidance on it.
in case of a mutual will, that is. Mirror will is that mirror will is there's no term like mirror will. It just means separate will. You make your will, I make my will. I leave everything to her, she leaves everything to me. There's no case of a challenge. But if it's a mutual will, we make one will, and on one page we write that based on this you will give me, I will. Then yes. So don't make that. Make it in one separate.
So we'll be ending the session right now. Thank you for your guidance, and I hope many of the queries are solved. Almost all of the queries are solved. So thank you very much again, and hope we see you again soon. Now we'll go for lunch and proceed.